You'd be shocked how many car accident victims do everything right until they make this one mistake after their crash. They think they're helping their case by giving a simple statement or signing some paperwork for the insurance company, but they've just given the insurance company what it needs to deny or undercut your entire claim. I'm Pablo Tamayo, an accident attorney here in Florida who's been practicing for almost 2 decades, and I've seen firsthand how quick, careless moves can cost people a compensation they may be legally entitled to. This video walks you through exactly what not to say, sign, or do after a crash, so you don't accidentally sabotage your case before it even starts. Watch to the end so you protect your rights, keep your claim alive, and don't get blindsided by the other side's tactics. Let's start with what seems like the most innocent moment. When they ask, "How are you feeling?" Well, you're still in shock. You want to sound calm, so you say something like, "Okay, just a little sore," but that gets documented. And later, when your neck starts hurting or your back needs physical therapy, they point back to those exact words, just a little sore. Not injured, not serious, just sore. This happened to clients many times. In one instance, a woman was rear-ended at a stoplight, and she told the adjuster she just felt stiff, but she thought she'd be all right. A few weeks later, her neck was so stiff that she couldn't even turn her head to the side. Doctors found a herniated disc injury to her spine, but it didn't matter. The insurance company clung to her first sentence and used it to minimize everything that came after. That's not an accident. Insurance adjusters in Florida are trained to take detailed notes from the very first call. If you say things like, "It happened so fast," or "I didn't see them even coming," they might use that to suggest you weren't paying attention. If you say, "I guess I could have braked sooner," something like that, they'll say the crash was your fault. And if Florida's comparative negligence laws apply, even 10 or 20% fault on you means a 20% cut to your total payment. Now let me show you how subtle this can be. Another person told an adjuster that she had the green light, but admitted she didn't see the other car right away. She was being honest, but they twisted that to try and assign partial blame to her for the crash. By the time the person called us, the adjuster had already valued the case based on the shared fault, and it was an uphill battle to get top dollar for that claim. But here's what most people never realize until it's too late. Your injuries can and often do get worse after the first day. The adjuster asks what hurts, you list a few things, they take notes, and they offer you a settlement, something quick, cash in your hands to make you go away. Another gentleman took a quick $3,000 settlement within the first week of the accident. He was sore, but thought he would be okay. Well, fast forward over a year later, he needed surgery, but he'd already signed the release. Game over. In Florida, once you settle, you're done. You don't get to renegotiate, not when the injury flares up again later, not if you lose your job because of it, not even if you can't walk without paying. The moment you sign those papers, you waive your rights for that accident. And here's where it gets even sneakier. Adjusters often ask for a recorded statement, or they say, "Can we just confirm your injuries with your doctor?" Sounds routine, but they're not gathering information for you. They're building the case against you. Now, we had a client in Miami who gave a reported statement. He mentioned his knee pain, but he didn't really talk about his back discomfort since his knee pain was so unbearable that it was front and center in his mind. Well, later, they claimed that the back injury wasn't related. Why? Because he never mentioned it on that first call. And so this is what we tell every client. Do not give them evidence they didn't earn. Don't hand over medical history or give statements or share photos without talking to someone who's been through this process thousands of times on behalf of their clients. And here's the biggest reason to keep the phone on silent until you've had legal help. Leverage. The moment the adjuster knows you don't have a lawyer, they want to move fast. They'll act friendly. They'll offer you something that sounds generous, because once you accept, you lose all your power. And so let me be blunt. The first offer is almost never enough. I've seen clients go from $4,000 to $40,000 just because we knew how to push back. Not with drama, just facts, timelines, evidence, and the law. Insurance companies are built to settle fast and settle low. That's their job. Ours is to slow it down, uncover what you're really owed, build your case, and hold them accountable. So what should you do? Easy. Talk to a lawyer first, a real Florida injury attorney, someone who's local, knows the laws, and offers a free consultation. You don't pay anything unless we win. That means you have zero risk and potentially tens of thousands of dollars to gain just by waiting before you answer that adjuster call. Don't let them use your words as a weapon against you. Don't let one polite sentence become a costly mistake in your case. And don't sign away your rights before you even know what you're dealing with. So to recap, answering the insurance company too early can, number 1, get your own words used against you. 2, accidentally make you seem at fault. 3, miss injuries that show up later. 4, give away evidence you can't get back. 5, kill your ability to negotiate a fair settlement. So take a breath, make one smart call, protect your case before it slips away. If this helped, you need to watch the next video. How much is my car crash claim worth? I'll break down what actually goes into the value of a case in Florida and how to make sure you don't miss a single dollar. Your future may depend on it. So I'll see you over there.